Could you see correctly the presentation? Okay. So, thanks, Michelle. So first I want to thank Michelle and the other staff of the project for your kind invitations to be involved in the project and to talk about today briefly about the potential impact of fundamental human rights in eviction proceedings and the right to property. What are the limits? And I will talk from the Spanish perspective mainly. To begin with, just brief overview, because you already know that. The right to adequate housing is regulated in Article 25 of the Universal Declaration of Human Rights. Also is established, regulated in Article 11 of the International Covenant on Economic, Social, and Cultural Rights, and according to the European Social and Cultural Rights Committee, General Comment number 4, the right of adequate housing includes these elements: legal security of tenure, affordability, habitability, accessibility, and so on. According to the committee, there are a number of duties of the contracting parties, take appropriate steps to ensure the realization of this right, to provide to the maximum of the available resources alternative accommodation for evicted persons who need it. Evictions shouldn't render individuals homeless, and the state parties can choose a variety of policies to achieve this purpose, but they should be efficient, effective in protecting the right to adequate housing. We have this UN Special Rapporteur on adequate housing, but in recent years, this individual complaint mechanism has gained importance. Since 2013, there exists this optional protocol which creates a complaints mechanism for victims. Anyone can complain before the UN Committee on Economic, Social, and Cultural Rights, which is a body of 18 independent experts that monitors implementation of the covenant by its state parties. And nowadays, this committee has a lot of work, thanks to Spanish citizens. I'm going to talk about this in a minute, but just remind this General Comment number 7 on forced evictions, according to which forced evictions are incompatible with the requirements of the covenant, but some evictions may be justifiable. For instance, in case of persistence non-payment of the rent. But sorry
to interrupt, but we don't see your slides. We still are on the same first slide. Oh, Okay, great. Okay, sorry.
Can you see now the slide, the correct slide?
We only see first slides, so we only see your title.
Oh my God! So now?
Now it's better. Now we switch, but now we only see your first slides, but I'm now on 4, I guess, already.
Okay, now you can see.
Exactly.
Okay, you will see also the notes. That's okay. Okay, so yes, I have mentioned this. These 2 articles, these two international instruments, the General Comment from the UN Committee. You can see here the elements that are included within the concept of adequate housing. This is the duties of the contracting parties, I have already mentioned. And I was talking about this General Comment number 7, right, on the forced evictions. And even if the evictions is considered to be justified, it should be carried out in strict compliance with the relevant provisions of international human rights law and in accordance with general principles of reasonableness and proportionality. So I was saying that, UN committee has a lot of work today due to the Spanish citizens, because almost 100% of the total number of pending cases submitted to the UN committee are from Spain, and relate to Article 11 of the Covenant. And this is due to the relevant role of civil society and social movements are very active in Spain, and they want to change the current status quo. So there are relevant cases related to Spain so far. There are these 3 cases in which the UN committee held that a violation of the right to adequate housing took place. And it's important to highlight that they involve not only, they relate not only to evictions, but also to the evictions for the non-payment of the rent, tenancy contracts, but also evictions relating to squatters. In this communication 37 2018, in this case, single mother with 6 children squatting a vacant apartment owned by a financial firm was when evicted, and the UN committee held that a violation of the right to adequate housing took place. Which were the relevant messages?
Hector, sorry to interrupt again. Sorry, but we lost your presentation, I guess. I think that happens with more people, right? There's no PowerPoint presentation anymore.
Okay, I'm trying again. Okay.
Yeah.
You can see. Can you?
Yeah.
You
now
can
you're back.
Yes.
Sorry for all the technical troubles. Yeah, it's better. So
now it works.
Good luck. Fingers crossed. Yeah.
Yeah, it works now. Oh, I'm sorry. Okay, but from the very beginning, just this is the articles I mentioned. Where the right to adequate housing is regulated at the international level. The elements that are included within the concept, according to General Comment number 4, the duties. You can see they have the contacting parties. Here, the optional protocol that creates a complaints mechanism for victims, and also it is worth highlighting this General Comment number 7. And Spain is leading the change. Almost 100% of the total number of pending cases submitted to the UN committee, thanks to this individual complaints mechanism, are from Spain, and right to Article 11, thanks to the role of civil society and social movements. And this is the relevant cases related to Spain so far, that relate not only to tenancy contracts between private persons, but also to squatters. And in all these 3 cases, the UN committee hold that a violation of the right to adequate housing took place. So, which are the key messages from these cases? Evictions without an assessment of proportionality by authorities constituted a violation of the right to adequate housing. So the UN committee recommends to regulate such a possibility in Spanish law. It hasn't been regulated so far. And the state has taken all the necessary steps to the maximum of its available resources to ensure that these evictions affecting persons who lack the resources to secure alternative houses are only carried out after there has been a genuine effective consultation, and it is related to the third key message. So temporary housing constitutes a violation of the right to adequate housing, so they have to do their best. They must to allocate the maximum of its available resources to provide alternative accommodations to the people facing evictions, and this accommodation shouldn't be temporary. And also there is another recommendation concerning squatters. Because if you are squatting, then you are not are not able to appear in the list of home applicants. Here we have a contrasting view. The European Convention on Human Rights doesn't establish an enforceable right to housing, but Article 8 lays down that everyone has the right to respect for his private and family life, his home and his correspondence. And according to the European Court of Human Rights, the loss of home is the most extreme form of interference in the right to respectful home, and any person who suffers the loss of the home has the right to have an independent court and decide the proportionality of the measure. However, according to the last case, this case was 3 years ago, the balance between the rights and interests of tenants and private landlords should be understood by legislation. In private law relationships, it's not possible to apply the proportionality principle. So there is no way that we can apply directly Article 8 to private law relationships, and consequently that the court uses the proportionality of the measure to see whether this interference is in accordance with the European Convention on Human Rights. So we have here a contrasting view.
Hector, we're still stuck at your slide number 7, so we don't see the contrasting view slide.
Now?
Not yet.
Which one do you see now?
I can also share my screen. Maybe that better? Maybe that works better?
Yeah, maybe.
Let's try that.
I don't know why it doesn't work properly. Because I changed my slides without any problem. I stop sharing, or maybe you can.
I can do
yes.
so. This is the slide you're working on right now.
Yeah.
Great. Just tell me when I move to the next slide.
Okay, you can move now. Okay. You can see the next one?
I guess so. Yeah, people are seeing the next slide.
Yes.
Okay. Yes. Okay. So it's time to talk about, the limits, how these, to what extent the views from the committee, these cases can have any impact, on national legal systems. So the first question is, to what extent the views and recommendations from the UN committee are binding to national authorities? And of course, there are countries such as that the European Convention on Human Rights and the UN Covenant are part of the internal legal systems. In Spain, we have this Article 10 of the Spanish Constitution, but the problem is that the judges don't consider these recommendations, these views binding, even though treaty is a legally binding instrument according to the Spanish Constitution, and it is the same more or less in other countries such as UK and the Netherlands. However, there is this Spanish Supreme Court decision 3 years ago, and the Supreme Court held that the views adopted by UN committee might constitute a legal ground from a liability claim against the state. So if the committee says, well, you state might pay compensation to the author, then the state remains inactive, then the affected person is entitled to lodge a complaint before national courts, and he will or she will be entitled to compensation. But there is an ongoing discussion about the to what extent these general recommendations, abuse from the UN committee are binding to national courts. The second question is to what extent ownership rights might be affected by the UN Committee views and recommendations? Well, if we have a look at the recommendations, they don't touch owner rights, at least relation to the recommendation of the author. They focus on the duty to provide adequate housing, financial compensation, and so property rights may be affected through the assessment of the proportionality of the eviction. So in light of the lack of binding character of the UN Committee views on the part of Spanish, then their proportionality assessment requires national authorities to take action and regulate such procedure. And before entering into more detail in right to property, there is another question: is the contacted parties, if they implement the proportionality assessment? The question is how. And so the issue at stake is the limitation of eviction-related standards. So what the UN Committee says in relation to right of property, they say, well, the right to private property is not a covenant right, but recognizes the committee that the state party has a legitimate interest in ensuring protection of all rights established in its legal system, so long as this doesn't conflict with the rights contained in the covenant. Also, it establishes a distinction between properties belonging to individuals and to financial institutions. And in relation to the principle of proportionality, it makes reference to the facts. It may be necessary to suspend or postpone the eviction order, and they even mention some aspects to be considered: the occupation in good faith of the occupants, their personal circumstances, and whether they have cooperated with authorities in search for solution to the situation. So the right of property is not regulated in the covenant, but it will be taken into consideration at national level, for instance, in Spain. So the question is, at the end, is how the proportionality test could fit within the whole legal framework. Because now the right of property comes into see, join the picture. For instance, squatting is a criminal offense in Spain. And according to the European Court of Human Rights, squatters deserve less protections than in other cases. This contrasts with the approach taken by the UN Committee. We have seen that one of the cases related to squatters, and they say that, well, if they are illegally occupying a dwelling, well, it doesn't matter for the protection of the right to housing. And it remains to be seen, in this case, the impact of a proportionality test, that takes into considerations the interests of both owners and squatters. Because judges could say, well, squatting is a criminal offense in Spain. So even if I take into account the personal circumstances of the occupants, I'm going to protect the rights of the owner. Also, a few years ago, a law went into force precisely to speed up the eviction proceedings. And this law gives the squatters 5 days only to present evidence of the right to possess. And if they don't provide evidence, the court will order the squatters to release their property immediately. And this law was challenged before the Constitutional Court. And the Spanish Constitutional Court held in 2019 that, well, Article 47 is not a fundamental right. It's an article where the right to housing is foreseen. Article 11 of the UN Covenant doesn't provide subjective rights to the citizens. International instruments cannot be used as a parameter of the legality of a national rule. And this law established the duty for the courts to inform social services about the eviction. So, and in fact, this duty related not only to squatters, but has general applications to any person facing eviction. So, for the Spanish Constitutional Court, well, squatting is a criminal offense in Spain. Right to housing is not a fundamental right, and the UN Covenant doesn't provide subjective rights to the citizens. So, taking into account this perspective of the rights of property, I think that the impact of the proportionality assessment in Spain in relation to squatters, I think, will be limited. I think that in the Netherlands also, courts have allowed the evictions to go on, even cases in which squatters have been involved. In the Netherlands, you have the proportionality principle regulated in the law. So in the case of the squatters, for instance, so I have my doubts about the potential impact of the proportionality test. So another question is that, according to the UN Committee, financial institutions should be treated differently. From the right of property perspective, well, such a distinction, I don't see, the reason why financial institutions should be treated differently if we take just the right of property, okay? But it's true that we have here, I have pointed out, the social function of the property. But this means, anyway, that housing is an asset with some particularities as an object of property. Well, it seems to be the case in Spain already. There are rules that only affect entities such as banks and owners. So, for instance, they must pay taxes if they own empty dwellings for a minimum period of time, and they don't rent it out to those in need. These dwellings can also be expropriated by the administration in these cases, for example, in Catalonia or in the Basque Country. The administration, in case these empty dwellings are in such situation for a period of 2 years or more, the administration is entitled to impose fines. And also in the law that entered into force 3 years ago to speed up the eviction procedure in case of squatters, legal entities are excluded from the subjective scope of the law. So this specific process is all available for public bodies and individuals, natural persons. So it seems that, at least in Spain, there are rules that treat housing, the property, the ownership of housing, differently. So it seems that housing is an an asset with some particularities, not of property. And I quote here the social function of the property, which could be the legal ground to establish such differentiation at national level. Regarding the scope, the proportionality test implies procedural safeguards and measures after eviction. So here we have a case of the European Convention on Human Rights in which the importance of social assistance for assessing the proportionality was stressed. It links with this number 6. The idea is that, okay, we have a list of elements to be taken into consideration, and if there is no alternative accommodation, then the court can suspend, postpone the eviction order. And the question is, well, is there any limit in time? The European Convention on Human Rights last year accepted the possibility to freeze enforcement of evictions during 7 months. And again, we have here the role of the social function of the property. For example, in Spain, a moratoria entering into force was implemented in 2013, and it's still in force until 2024. So when a legal entity, a bank, enforces the mortgage, and then no one goes to the public action, and then the bank becomes the owner of this property, then is the owner, but according to the law that entered into force in 2013, the bank is not entitled to evict these people. So these people stay there, and it's not clear even if they have the duty to pay any rent to the legal entity in this case. So we have examples of these moratorias, of these.
Hector, sorry, this is Alexandra. We can't see your video. We can't see your video. We can't see the right slide. I think your slider is off. You went backwards and forwards.
I can hear you properly. You couldn't see the presentation.
We can, but we're on the slide, a slide that you've already shown, I think, the effectiveness of UNCSR's views, yes. So I think you went backwards rather than forwards when you moved your slide.
Okay.
Sorry,
So
sorry.
here
Hector, which slide do you want to show?
From Vancouver, Canada.
Well,
Prince?
this one.
This one? You want to say this one? Number 5, 6, 7?
Number 1 to 4.
1 to 4.
1 to 4, sorry.
This one.
Okay, yeah. 1 to 4, okay, yeah. Yeah, I was talking about the scope, the procedural safeguards. And if you jump to the next slide, to number 12, okay, then I was talking about this number 6. The idea is that the court can suspend or postpone the eviction order, but what is the limit? Because at some time, I think that the social function of the property becomes an expropriation, or could be an expropriation. So you can postpone the eviction indefinitely. So we have this European Convention on Human Rights ruling, and we have examples in Spain of moratorias. And there are, and if we go back to slide number 11, sorry about that. The question here is, okay, in Poland, is prohibited the eviction to nowhere, the eviction without an alternative accommodation. But in this case, so the owners are entitled to compensation. So in case of the proportionality test being implemented in Spain or in other countries, and if the postponer or if it takes years, for instance, for the owner to take possession of the property, well, maybe it will be entitled or not to compensation. Another aspect is that the European Court of Human Rights places importance on vulnerable groups. Jordanova, the European Court of Human Rights, has developed the proportionality test on the basis of the vulnerable groups, and it seems that the Union Committee places more importance on discrimination issues. But at the end of the day, both could be implemented into the proportionality test. You can jump, please, to the next slide. Okay. And here we have the elements of the proportionality test according to the European Convention on Rights, according to the Union Committee. But which other elements related to the owner positions could be taken into account to strike a balance between the interest at stake? Well, if we have a mortgage enforcement, then we have the Irish Land and Contingency Law Reform, that Act 2019, that enable courts to consider whether making a possession order is proportionate and in full respect of the rights of the borrower. And this act that foresees a number of elements to be taken into account. But if we face a conflict between individuals, property owner, tenant, then it remains to be seen which other elements should be taken into consideration on the part of the owners to complete all these elements of the proportionality test that refers mainly to the position. And number 7, despite of national regulation, in absence of such standards, maybe in the end we could ending up with despite of outcomes, in relation to this proportionality test. So it's 20 minutes left. So please, next slide. I'm going to explain, to quote a little bit the European Social Charter, European Charter of Fundamental Rights. The right to housing is considered a social right in both the Charter and the European Social Charter. So the right to housing is considered a matter of national competence. Next slide, please. But we can't the application of the right to housing through the interpretation of EU consumer law. You are familiar with the case Cosinova, which linked Article 7 with the right to accommodation. So under EU law, the right to accommodation is a fundamental right, guaranteed under Article 7 of the Charter that foresees the right to privacy and family life. And the question is, on the legal reasoning is that Article 7 of the Charter must be interpreted according to Article 8 of the European Convention of Human Rights, that both foresee the right to privacy and family life. And Article 8 foresees the principle of proportionality. So we must interpret Article 7 of the Charter in conformity with Article 8 of the European Convention of Human Rights. This means that in consumer transactions, business-to-consumer transactions, the consumer are related to mortgage loan. If the loss of a home is an issue, thanks to the direct application of the EU Charter, Article 7, then the proportionality test can be applied to this business-to-consumer relationship, thanks to Article 7 of the Charter. Next slides, please. Because the provision of the Charter are binding to member states. No? However, this is application of the proportionality test of Article 8, the European Convention of Human Rights, thanks to the direct application of Article 7 that helps to overcome the problems of the horizontal application of the European Convention of Human Rights in private law transactions. There are limits to the application of such legal reasoning because only the Charter is applied to member states only when they are implementing union law, so potential application only to business-to-consumer transactions, and also further education and training of judges are necessary because they don't know the Charter, they don't apply the Charter, and also lawyers must be trained in the application of the EU Charter on Fundamental Rights. And next slide. Almost the last one. And also the Court of Justice of the European Union didn't balance in case the interest of consumer rights versus the creator rights to property enforcement. And it didn't use the concept of proportionality because they speak different language, whereas the European Convention on Human Rights makes reference to this interference that should be necessary in a democratic society, addressing social need, and so on. The Charter uses the concept of effectiveness and equivalence of EU law. Next slide, and I'm finishing now. So the application of the EU Charter to these business-to-consumer transactions could be a possibility, but what about the direct application of human rights? We have cases. At least in Spain, the order of the Court of First Instance of Madrid, which suspended the eviction of a tenant with 3 minors free minor children on the basis of the Convention on the Rights of the Child and other fundamental rights. So these fundamental rights were applied directly. And also, we have these Spanish Supreme Court decisions, the Administrative Chamber, that obliged the court of first instance to take into account the personal circumstances of those occupying social housing on the basis of a number of international and national instruments and norms and rules, such as the legal protection of minors. But the people facing eviction has tried to apply these Supreme Court decisions to private law transactions, and provincial courts in Spain say no. That's administrative law. That's public law. Is another story. It's not a private law relationship, so we are not going to apply this standard. Next slide. So, thank you for your attention. Sorry for these technical problems. The problem I had is that I was looking at my own PowerPoint, so I was passing my slides, and at the same time, Michelle, you were passing the slides that you are sharing now. So this is why we didn't pass the same, and But well, sorry for this, and I wanted just to point out briefly how these international instruments and human rights and can be applied in private law transactions, because it is difficult, because they speak different language, even though they concede in the proportionality assessment of the eviction, of how the eviction is going to affect the rights of the occupants. But it will be difficult to find such standards if we just leave these to national courts. So thank you for your attention. Sorry for delay, for the technical problem. So if you have any question, I guess that I have more, maybe you have more questions than answers than before. But well, no.
I think there's plenty of room. So we have like 15 minutes for a question and answer. So, but first of all, I would like to thank you, Héctor, for this interesting presentation. I think it gives a good overview of all the legal instruments that constitute the right to housing. But I'm pretty sure that there are questions from the audience. Are there any questions? Please just shout out. I don't know whether there's a way to raise your hand in this. I already see Michelle Bruin. I have a question. Let's start with Michelle. Michelle, the floor is yours. Koldo has a question. We will have time. Michelle, the floor is yours.
Thank you. And Héctor, thank you very much for your very interesting presentation. I had a question because you mentioned multiple times that there are certain eviction moratoria installed. And of course, there were plenty moratoria during the COVID crisis in a lot of countries. And I was wondering, the right to housing, which was basically strengthened during these eviction moratoria. Do you think that these moratoria and decisions that have been taken about these moratoria, if they will have an effect in the future about the interpretation of the right to housing and the right to property?
Well, you are asking about the current moratoria, the one that has been implemented in the pandemic times, or also to the one that was implemented in 2013? Are you referring to both? Well, the problem is that...
Yeah, more in general. I think that these eviction moratoria really show a strength of the right to housing. Especially in the situation, right to housing versus the right to property. And I was wondering, do you think that it will have an effect on future decisions after the moratoria situation?
Yes, I think that it shows that, of course, the owners complain, why I should wait 6 or 1 month to initiate the eviction proceeding. But it's an example of the application of the social function of the property in there. So you are limiting the right of property. You are limiting the rights of the owners to seek the possession of the property. So it could just extend the protection of debtors. Well, at the end of the day, the problem is that it depends on the legislator or the lawmaker, because now the measures come to an end, and then these people will see how these people will be protected. But this moratoria shows that states can have influence on the rights of owners thanks to the social function of the property. So it shows the way forward. They have limited this since 2013. These people are living there and occupying the property and not paying anything. And in exceptional circumstances, of course, it's hard to protect the people, by law. But it shows the way to further, measures that can be taken, can be implemented in the future. So, maybe in 1 year, we don't have such these governments deriving from the pandemic, but at least we will have this moratoria has been in place, and there are examples that show that national lawmakers can influence owner rights, because now at the end of the day you strike a balance, and then you want to protect the people facing evictions. You must restrict somehow the rights of owners. I think there are examples. They show the way forward.
Thanks.
Thank you.
I also see that Koldo Kasla, floor is yours.
Thanks very much. Thank you for organizing this event, and Héctor, thanks very much for your talk. I have one. My name is Koldo from the University of Essex in the UK. I have one clarification and then one question. I think the clarification is about the point about the legally binding nature of treaty body decisions in Spain. And while it is true that in July 2018 the Supreme Court said that they could be binding in the González Carreño case, then there was this other case in February 2020 when the Supreme Court sort of changed course and said the opposite. So I think nowadays, since February 2020 at least, I don't think it is fair to say that might be the position of the Supreme Court. I think the Supreme Court has gone back to the original position, which is that only rulings by the European Court of Human Rights are legally binding. None of the treaty bodies' decisions are. And contradicting something that I actually had written myself somewhere. But I think since February 2020, we cannot make that point anymore. But that's only one point of clarification. But then I have a question for you, Héctor, and it has to do with the legal reform in 2019 to the Civil Procedure Code, where the code says since 2019 that judges have the responsibility to make sure that there is coordination between judiciary and social services. And recently, the UN committee has said a couple of times in El Gumari v. Spain and El Ayubi v. Spain, both of them result in February, that legal change from 2019 might be enough to comply with the requirements of proportionality assessment of Article 11. Personally, I don't think that will be a correct interpretation. I think the 2019 legal change is an improvement, but it doesn't reach the level of requirement of Article 11 of proportionality test, because the legal change of 2019 requires judiciary and social services to coordinate, but there is no proportionality test, as you said, in Spain. But I fear that from now on, and because there are so many cases emerging from Spain on housing, as you said, that 90 or 95% of the backlog is about housing in Spain, I fear that the UN committee might take a conservative turn from now on and say, okay, then 2019 change is enough to meet the standards. And the two paragraphs of these two cases, and I will provide the reference here in the chat, in my opinion, are a reason to be a little bit concerned about it. Do you share this concern? Are you following this? Thank you.
Yes, in relation to the last question, I totally agree. In fact, it's what the Spanish government says to the UN committee. in the follow-up of the recommendation, say, well, we implemented such coordination between the courts and social services. Well, what else do you want to do? And I think that it's not enough. It's not enough because they don't take, as you mentioned, the personal circumstances of the people affected by the evictions. There is no proportionality test in this act because they want just to, they have 5 days to provide legal title. And if they don't provide this title, then, they are evicted immediately. And if the court seeks the help, from social services, but it's maybe they offer alternative accommodation, maybe not, but there is the court doesn't strike, balance between the interest stake. So I completely agree with you that this is the position of the Spanish government, in the follow-up. Because of course, after these cases, there's a follow-up, and the new committee asks, Spain, well, what have to do in relation to these cases? And they say, well, we have implemented such coordination, but they are reluctant to implement the proportionality test. And I think that, in order to comply with this, with Article 11, it should be implemented a proper proportionality test. So I agree with you, it's not enough. And in relation to the first question, well, I quoted, you're right. I quoted the Supreme Court decision from 2018 just to show that, there's an ongoing discussion about the bindingness, to what extent these views are binding for national authorities. But, you're right. It's attending to the last judgment you mentioned, it's a pity, but and in relation also to the second question, it means that these cases and the cases to come won't have an impact, on national legislation. And I'm afraid, that at the end they just, they don't implement the proportionality test, and even, the Young Committee has held that, there is a clear violation of Article 11. At the end of the day, nothing will change, I guess. So I agree with you.
I think there's plenty of room for more discussion on this with all these Spanish experts here on board. Are there any other questions so far? Yeah, so Jane Ball, floor is yours. You need to switch on your mic.
I've just done that. Yes, great. Thanks. Thank you very much for the talk and bringing us up to date, Hector. Great. What I was wondering is whether you see COVID making any difference, because it has done in England. For a start, we have house prices shooting through the roof because people are working at home and they all want to live on the coast by the sea. So rural properties have shot up by 14% in a year. But yet that's on the one hand, that's a property thing. And I caught in your account that at the UN, this proportionality business involves the resources of the government. And the other aspect of COVID, of course, is not just how expensive property is to house people, but the fact that they've got these huge debts. The government has these huge debts. So what difference do you see the COVID making to the rights situation in Spain?
The COVID?
Yeah.
Well, so I don't know. I mean, so can you ask again the question, please?
Well, COVID makes it. I'm attaching this to the proportionality question and to the resources of government, which would shift the balance of proportionality. So the government can't do anything because it is stretched, because house prices have gone up, because everybody's working at home, and also they've got huge debts from social support for everybody, and a tenant freeze on tenant eviction as well, actually. Commercial as well as residential.
Okay,
Yeah.
so you say,
In the future,
states couldn't afford, these temporary accommodations. They don't have enough money, They have debts, no, you say? So how is going to affect this, the proportionality? Well, that's the problem, because one of the items, that is included within the proportionality test is whether there is no alternative accommodation, no? And of course, if there is no money, there is no alternative accommodation. That's the problem, is that, well, you have these people, there's always, but one question, one answer could be, one way could be, well, there is an alternative accommodation. This necessarily means that the evictions is going to be postponed. I don't know, because there are other reasons to be taken into account. Maybe tenants are not acting in good faith. Maybe the illegal occupiers have not accepted previous offers of social housing. So that's one of the questions I have here is that if the eviction, for instance, is proportionate, maybe they have acted in good faith, the owner's right must be protected, but if there is no alternative accommodation, then the courts could say, well, but from the perspective of the right of property, owners shouldn't assume the duty of the state to provide alternative accommodation, because a private owner. So if you don't have alternative accommodation, should the private owners bear the responsibility, assume this duty, and just wait until you provide alternative accommodation to these people, and maybe it takes years, months. So, well, we'll see. But I think that the mere fact of not having alternative accommodation, it doesn't mean that the eviction is going to be forward, because there are other items to be considered. But in such a case, if we the court decide, okay, there is no alternative accommodation, so the eviction is postponed, then we should think about this compensation I mentioned before, because the owners are assuming a duty that corresponds to the state. So if the evictions take 2, 3, 4, 5 years, 10 years, until there is alternative accommodation. So who pays this? Is the owners must assume this duty on the basis of social function of the property. They are entitled to compensation, and as happens in Poland. I don't know if I've answered your question, Jane, but it's true.
I think we can talk for this for hours, right? So this impact of COVID and on the housing crisis and stuff like that. But it's o'clock, so we need to wrap this meeting up, right? So I just saw Gustav Müller entering the room, but we're already closing the meeting. But it's great to see you. Hector, thanks so much for all your interesting thoughts and your presentation. Thanks for all being here, being present. So there are a lot of people from all over the world. So I saw even people from Canada and South Africa now joining. So we have a worldwide audience. So great to see you. Now we have a break for this eviction talk series, but in September we will with a very great speaker. So Professor Peter Kenna will talk about the right to housing in September. September 15, he will talk about 4 o'clock Dutch time, so that will be probably 3 o'clock his time. And please check the your own time regions, right? So to be present there. Later on this year, we will have more eviction talks. So we already have a confirmation from Jesse Homan from Australia that will talk about the right to housing. But there will be also more people from all over the world speaking on housing rights, the housing law, the right to housing later on this year. So we continue to do this monthly talk. For now, have a great holiday, summer holiday. Stay safe. Get your vaccination, I would say. And thanks so much for being here. So it was lovely to see you all. Bye.
Bye. Thank you.
Bye.